Welcome to everyone. This is the second in a series of Doughty Street seminars on the Mental Health Bill. The first seminar provided an overview of the bill, and this is the first of the deep dive sessions. And what the speakers are going to be looking at today is essentially advanced choice documents and the changes to the treatment without consent provisions. There'll be an opportunity to ask questions after each speaker. The convenient way of doing that will be to use the question and answer button at the bottom of your screen. The chat and the raised hand buttons have actually been disabled for today. So if you have questions, please use the Q&A button. So we're going to hear first from Elizabeth Cleaver, who's a very experienced mental health specialist at Doughty Street, and she's going to be talking about the advanced care documents and also providing an update of where the bill currently stands. After she's spoken, there'll be an opportunity to ask questions of her, and then we'll hear from Laura Shapcott. She's going to respond to what Elizabeth has said. She's an expert by experience. So I'll pass over to Elizabeth Cleaver.
Thank you very much, Anselm, and welcome everyone. I'm just going to start by sharing the screen so that we can have a look at my slides. There we go. Great. Good start. All right. So welcome everyone to this second seminar in our series on the mental health bill. Of course, the biggest reform in mental health detention powers in our generation. So really important piece of legislation that's currently going through Parliament. I'm going to start with a little update on where we are with the bill, because it's all change. We have indeed reached the committee stage this week. So the bill is currently going through the House of Lords. And we had introduction of the bill on 6th November 2024. The committee stage completed just this week. We had the second stage of the committee on the 24th of February. I've included for you there the link to the website, the Parliament website, where you can look at the progress of the bill and also look at what's been said in Hansard. There's also a very helpful list of publications, including of the amendments that are being discussed at the moment. So we will shortly be moving on to the report stage in the House of Lords. I think there's rumours it's going to be towards the end of March, and then there will be the third reading before the bill moves through to the Commons. We expect the royal assent to be in this summer, so coming up really quite quickly, and then a slow implementation period, possibly over a period of the next 10 years in light of the extent of this publication, this bill. So a lot of work still to be done on that. So I thought I'd talk through some of the amendments that are in discussion at the moment in the House of Lords. So there is a list of the amendments as they stood on the 20th of February. There's now also an updated version of the bill as it stands following the committee stage. So that's available on the website as well. So I thought I would just take you through some of the amendments that are being discussed at the moment in the House of Lords. So the first was proposal for an independent mental health commissioner. And that commissioner would be looking at overseeing the implementation of functions that are being exercised under both the Mental Capacity Act and the Mental Health Act 1983. A proposal, really importantly, obviously this came out a lot from the review of the Mental Health Act, so a proposal to address racial disparities by nominating an individual within each mental health unit who would be responsible specifically for monitoring and addressing any issues around racial disparities in the application of the Act. Thirdly, a duty on ICBs to secure sufficient resources for services in the community. It's quite a broad duty there, but that was up for discussion as well in the Lords.
Elizabeth, I think I think for some people the slides are not moving ahead.
I hadn't been moving them, so maybe that's why.
Right.
Have you, Anselm, have you got a slide that says proposed amendments and starts with little 4 at the moment?
No, I think some of those in attendance and myself are still just on the first slide, the title slide.
Okay. Right, I'm not really sure how to address that.
No, okay.
You could stop sharing that again. I think you might have to stop sharing. And
I'll stop sharing and we'll try again and see.
Presentation mode, yeah.
Apologies, everyone. Is that any better for everyone? Are we on slide 2 there?
Still on the title slide, I think.
Stop share, the red button. Oh, just underneath update on the bill. Try that. Then I think just try this share again.
Yeah. Right, okay, now.
Try that one. Share. And then go to slideshow. Is that moving through?
Do you have slide 2 there?
No, I'm afraid not. Maybe you could have one more go and then give us the presentation.
If not, so, I mean, I'm really just, I mean, I'm just going through the slides really and reading through them. So I think anyone who is missing too much, there will be slides circulated after the session as well. But I will just try once more.
That's moved through, yeah.
If you
well done. So we're on slide 2 now, yeah.
Okay, so maybe I just need to work through this one. All right. So moving through, so I was looking at the amendments and I just got through to the statutory competency test. So this is an amendment that's been discussed also in the House of Lords, which was looking at whether or not there had to be a definition of competency for people under the age of 16, so mirroring a test for capacity on a statutory basis, but for that to be included within the Mental Health Act as amended. I think there doesn't seem to be much appetite currently in government for that, but that's one of the amendments that's still in discussion. The Secretary of State to report on alternative places of safety, and that included in the community. So you will remember that the bill provides for places of safety within police stations, for example, no longer to be an option for individuals in a mental health crisis. So looking at alternative places of safety, a clearer definition of the serious harm test. I think there has been some criticism that the serious harm test is a little bit broad, and how do we define that? So a proposal for that to be defined as death or serious personal injury, whether physical or psychological, so making that a lot clearer within the bill itself. Some provisions to prevent detention of children on adult wards. I think very welcome. Provisions for recording the use of force and longer-term segregation, and also for there to be mandatory care and treatment reviews for people who are in longer-term segregation. So in some ways, extending the use of CTRs, which we have currently for people with autism and learning disabilities, of that to be extended to anyone who is in hospital on longer-term segregation. Some miscellaneous provisions, including services in the community to manage people who are going through withdrawal symptoms from coming off psychiatric medication. Thought that was quite interesting. A costed plan for the provision of community services for individuals with learning disability and autism. And we will discuss that a lot more in the next seminar on learning disabilities and autism, but that seems to be the elephant in the room, really, in terms of how we're going to make sure that if people with learning disabilities and autism are not detained under the Mental Health Act, how their care needs are going to be met in the community. And then further amendments that have been discussed, and again, there was debate this week on that. If you look at Hansard, so banning the use of profit-making companies to deliver treatment under the Mental Health Act. And there was some quite interesting discussion about how much money the NHS is spending on beds run by services such as the Priory Group and Signet, and maybe some surprises to just how many millions of pounds is being spent every year on these private companies, and the proposal to ban the use of profit making when delivering services under the Mental Health Act. So looking at less private provision effectively. Another point about mental health tribunals, and we discussed this a little bit in the last webinar. So looking at mental health tribunals to be able to determine challenges to treatment decisions. At the moment, that's not provided for in the bill, and therefore we'll talk a bit more obviously about treatment decisions a bit later, but there isn't really a form of recourse at the moment to challenge clinical decisions made by a responsible clinician, although there was some discussion about the tribunal possibly having a role in that. So that's still one of the amendments that's being proposed to the bill. Local authorities to have a general duty to promote mental health and well-being, which reminded me a little bit of the Care Act in a way. So having a broader duty to safeguard mental health in the community. And then the Secretary of State to report about how to ensure greater continuity of care for those who are discharged from secondary services to the care of their GP. And I think maybe this was an amendment aimed at the Valdo-Calocane situation, where a patient who's not engaged with secondary services was simply discharged to the care of their GP, and it's how that can be monitored to ensure that these people don't just fall out of the mental health system completely. So those were some of the amendments that are currently being discussed in the Lords. Again, it's watch this space. So a lot for further developments we can expect as we move towards the report stage and then to the House of Commons. So advanced choice documents. These were, I think, supposed to be quite a significant development really within mental health reform, looking at the role that these documents are going to be able to play for patients who maybe have had repeated contact with mental health services and have strong views about the way they wish to be treated if they are to require readmission to hospital. So I think this was expected to be quite a significant part in some ways of the reforms about consent to treatment. And actually what is provided for in the bill itself is fairly limited. So we have clause 42, which inserts new sections to the Act, and those are sections that are going to create a duty for ICBs, NHS England and local health boards in Wales to facilitate people to make advanced choice documents. And then there's some guidance notes about what an advanced choice document is. And an advanced choice document can be used by individuals to set out what they want and what they don't want while they are well, and when they have capacity or competence to do so, so that the document can be used by mental health professionals in the event they are assessed and potentially admitted for care and treatment either informally or formally under the Mental Health Act, and they lack capacity or competence to share these things at the time. So if you like, it's a document that's going to record what a patient would like in a particular scenario if they have to be admitted for treatment in the future. And it's a document that you can draw up when you are well to make your own choices about what's expected to happen in those circumstances. So then the guidance notes go on to say that it's usually a written statement, and that sets out what their decisions are, what their wishes and feelings are about matters that might be relevant to their assessment for admission in the future, care and treatment as a formal or an informal patient in the event that in the future they lose their capacity, they lack capacity or competence to make that decision in question. And then it also says that the document can also include advanced decisions under the Mental Capacity Act 2005. And so you will all be aware that the Mental Capacity Act does provide for advanced decisions also quite formally, but this is a separate instrument, if you like, to those. So looking at comparison really between advanced choice documents and what the Mental Capacity Act provides for, which are advanced decisions. So section 2426 of the Mental Capacity Act talks about advanced decisions to refuse treatment. So if you have capacity to make an advanced decision, you can draw that up, and that will be binding if in the future you lose your capacity and there is a question mark around whether this treatment ought to be given. So it's binding if it's valid and it's applicable to the relevant treatment. And of course, it's only valid if you had capacity at the time that you drew it up. And it's only valid in relation to life-sustaining treatment if that's specified on the advanced decision. So similarly to an LPA, where you have to specify whether it covers life-sustaining treatment. Now, an advanced decision is valid if it's in writing and it has been witnessed, but it can be overridden by detention or treatment under the Mental Health Act. So in other words, you can't take out an advanced decision that says that you don't want to be admitted under the Mental Health Act in the future. If you then your mental health deteriorates and you met the criteria for admission and treatment under the Mental Health Act, the advanced decision wouldn't apply in that situation. So with advanced choice documents, which are specifically aimed at treatment, mental health treatment effectively for patients, and is going to be referred to in the Mental Health Bill and the new Act, that amendment that I've just gone through doesn't specify whether advanced choice documents are going to be binding on clinicians. I think we can assume that they probably are not. So the only provision that we really have in the Act relates to ICBs, local authorities, enabling patients to prepare these documents. So really providing the resources for patients to be able to make their views known ahead of any future admissions for treatment for their mental health. So we don't have anything that says that you can have an advanced choice document that is going to be binding on clinicians. And maybe some concern there is whether or not it's these advanced choice documents are going to create an unrealistic expectation for some patients that if they are admitted to hospital, they don't need to worry because they are not going to have treatment imposed upon them, which is not, unfortunately, not necessarily the case. So advanced choice documents obviously really important, empowering for patients to set out what they would like to happen. But I think we can assume that a responsible clinician who feels that treatment is needed and it's given under the Act will be able to override those advanced choice documents. So that's what I wanted to say on ACDs. Anselm, unless there's any questions in the chat box you'd like to raise, I can hand over to Laura. I'll just stop sharing.
Right. Oh, let me give people a chance to ask questions in the Q&A if they wish. I mean, I've got a couple of points that you might wish to give your views on. The first is, to what extent do you think the advanced choice documents will affect decision-making by AMPs, because the Act specifically says that they're relevant when consideration is given to the person's admission to hospital. And I suppose the second thing it would be interesting to have your view on is whether their significance is limited by the fact that you have to have capacity to make an advance decision document, which seems to me to be a shortcoming of the scheme, because people who might, under the very technical law we now have, be held to lack capacity would still have a lot they want to say about their wishes, feelings, beliefs and values in relation to any future admission. But apparently they can't make one.
Really interesting, Anselm, and I completely agree with that. So your first question is what impacts are likely to have on a decision made by an AMP who's considering someone's admission. I think that's a really good point, and you would hope that that would be exactly the time where the document would be brought out and the discussion would happen with the patient about what they wish to happen and whether admission is the right step for them, or indeed whether formal admission is the right step for them. So I think it remains to be seen how these documents are going to be used in practice, but you would hope that that would be the first step, and that actually these advanced choice documents aren't just going to be relevant to medication or the treatment that they're going to receive on the ward, but also relevant to the decision to admit in the first place, and if so, how. And they might have a view about wanting to be admitted to their local unit that they know, rather than being sent out of area, which we know unfortunately happens quite frequently as well in crisis, and also for people who need specialist beds. Your second question was about wishes and feelings, and I agree that that's really important, because if an individual lacks capacity, they may still be able to express very clear wishes, and those are really important. And as court protection practitioners, obviously, Sophie and I, that's a very key part of the jigsaw when you're making decisions on in a person's best interest. What are their wishes, and indeed what were their wishes as expressed in the past as well? So I think that's a very important point, and potentially it is a lacuna there, that we don't really have provision for that, people who lack capacity. Yeah.
So there's two questions here on the Q&A. Thank you for that. So the first one, is the alternate place of safety also relevant for those with ASD or a learning disability? Any clarification of the community service provision for the same people, please?
Absolutely. I know that this is a very hot topic that is going to be discussed also in our seminar next week on the 4th of March about learning disabilities and autism. There is a huge lack of alternative community provision at the moment, and I think there's been some discussion about the need for, and certainly NHS England is live to the need for so-called crash pad facilities to be made available in the community for people who are in crisis, not necessarily actually due to a mental health crisis, but sometimes due to external factors where there is a breakdown in their community support. So it's one of the issues that's being debated and was on the amendments list, is to look at alternative places of safety. But I think they may be most acutely needed for people with learning disabilities and autism if they are not going to fall under the scope of the Act. There has got to be alternative crisis provision for them in the community if there is a breakdown in their package of care. Absolutely.
Okay, thank you.
Okay. Shall I introduce Laura Shapcott then?
Okay.
Thank you very much. Yes. So I'm really delighted that a very good friend of mine has joined us this evening, Laura Shapcott, who is an expert by experience. Well, she'll also tell us a bit about her current role within a large mental health trust in patient and carer involvement. But we're really delighted to be joined by her this evening to talk to us, not just on a professional level about her role in the trust where she works, but also a bit about her personal experience of receiving treatment in hospital for an eating disorder. So we're really delighted you joined us, Laura. And it would be really good to hear from you, starting point, what you think about advanced choice documents and whether the work that's been done within your trust in relation to those as well to prepare for their arrival, as it were. So over to you, Laura. Thank you.
Thank you. Yeah, so my name's Laura. I've got lived experience of being detained under the Mental Health Act. I had 2 9-month-long admissions about 10 years ago now for an eating disorder, both of which were under section. And I've also had an informal admission to an acute ward, but I was assessed under the Mental Health Act prior to that admission. I think I'll begin speaking a little bit about my experience because then I can contextualize it with kind of what I do now. I guess for me on that first admission, I couldn't have anticipated how unwell I was going to be. I did need NG feeding under restraint, and I needed that admission, but there were points during the admission where I felt completely powerless and like my voice meant nothing in terms of the treatment that I was being given. And that in itself was quite traumatizing. And it meant that in the lead up to my second admission, there was a really great anxiety that even though I was at a point where I had capacity to make decisions, that there would be a repeat of my first experience. And I think for me, if I'd had the opportunity to make a care plan with advanced choices about what I would like to happen if I became that unwell again and needed NG feeding, I think that could have been a much more positive experience. And I think for me also on my second admission, I was administered medications that didn't particularly agree with me, but they were continued even with SOAD input. And if I'd been able to make a decision about preferred medications prior to admission, a lot of the distress that was caused as a result of those medications and some quite long-lasting physical side effects might have been avoided, whether or not in the way the legislation is currently planned to change, those decisions would have been executed. I don't know, but I think for me, knowing that I had a place where I could put my views down about my treatment before reaching a point where my voice would have been not limited, but found it harder to be heard. I think that would have really made a difference. I guess then so now I'm mostly recovered. People have a different definition of recovery. I know that I could get to a better place than I am now. But I'm in a position where I'm able to work, and I'm now supporting people with lived experience, service users and carers, to use that lived experience to help improve mental health services. And I know that there was an ask from NHS England a year or so ago for all mental health trusts to reform their care planning, their care plan approach. And as part of that, a lot of trusts are moving towards personal wellbeing plans and kind of having an ongoing conversation about wishes, best interests, what's important to the individual, rather than conforming to these boxes on multiple different forms for various different things. And I know also that within our trust, when we're thinking about crisis planning, particularly if service users, when they are outside of hospital, are able to express what they would like to happen if they were in hospital and a particular situation happened, then where possible, if that's in writing, we are trying to do that. So an example might be a service user who says, when I get really agitated and distressed, actually the best thing for me is to be secluded, which as we're in a I guess generally we're trying to move away from using restrictive practice like that. But if someone is saying, actually, no, that is the best thing for me, when I reach that point, it kind of gives that permission for the team to do that, knowing that that's what the person has said that they need when they're well. So that's just one example, but there is a general move towards trying to work with people individually and understand what it is that they need. And I feel like when you combine the ask from NHS England to kind of transform care planning with the changes to the Mental Health Act, those advanced choice documents could actually be a really empowering way for people, service users, carers, and their treatment team to give people a voice when they're at the most vulnerable. I know that being able to say, if I need to be admitted to hospital again, I'd like you to use the medications you used last time and not use any others, then my experience of my second admission could have been very different. The same is true for NG feeding, and thinking about transitioning from NG feeding to oral food. If I'd been able to say, when I verbally say I want to have the nutrition orally, please can you give me that opportunity, rather than escalating and then needing to be restrained to be NG fed. I know we can't fully predict what's going to happen when the changes come into place, and depending on what amendments there are, but I'm hopeful that with a general change in approach of mental health services, that we will get where the changes were initially intended to get us. Are there any questions?
So on the Q&A here, it's Anselm. It says not a question, but I wanted to thank Laura for her courage and candour in sharing her story with us, and to wish her the best with her recovery and journey. Yeah. So
Thank you.
yeah, no, that was very helpful and very impressive. So
Thank
you
you.
very much. I don't know if there are any other questions at this stage. We'll be hearing from Laura a little later as well, because Sophie Miles is going to speak next. She's, of course, an expert on the Mental Health Act and the Mental Capacity Act, and an author. And she's going to speak about the changes to the treatment without consent provisions. And then when she's done that, Laura kindly agreed to give us her insights and response to the changes. So there's maybe a further question. So there's a question here. I just wonder how we could encourage other ICBs and trusts to engage in PPI as you are doing so successfully.
I think it's becoming more and more common, and I know within NHS England guidance, there is statutory guidance on involving service users and carers in service development. I think there's still a long way to go in getting to where it needs to be, to have that level of involvement. And I think one of the barriers is funding for it. And I guess the more people feedback at the value that lived experience can bring, hopefully it will become business as usual rather than like a privilege or something that's kind of yeah.
And that was well put. Thank you for that. Excellent. So maybe it's a good time now to move on to Sophie and her presentation, and then we can hear again from Laura after that. Thank you very much, Laura.
Yeah, thanks from me too, Laura. Absolutely amazing to hear from you. Really, it's so impressive, and I think really inspiring to hear about the work that you're doing at the moment. I'm attempting to move the slides along. I'm going to ask Anselm to say if the slide has moved from the title slide and if it's moving along at the moment. Is it moving?
It's not moved on my screen, Sophie.
Okay. Well, do you know what I'm going to do? I'm going to abandon the slides, and I will speak to the presentation, which I think is going to be fine anyway, and people will just have the slides anyway. So I'm going to speak about the consent to treatment provisions in the new bill. And my sort of starting point was to look at the independent review of the Mental Health Act, which was carried out by Sir Simon Wessely. And one of the things I'm trying to do is sort of compare the aims of that review with what we were actually getting. And so what Sir Simon said in his review about the consent to treatment was that improving patients and care and service users' ability to make decisions about their care and treatment is essential to upholding their dignity. And what we propose, he said, far earlier access to a SOAD as soon as the care and treatment plan is finalised, and we propose that the patient should be allowed to make a tribunal challenge to a treatment decision if both the RC and the SOAD have approved treatment to be necessary. And the review said that that was essential to human rights compliance. It should enable a patient to object to a specific treatment, provided that there's another treatment available, even if that is suboptimal. So what they're saying is that there should be an ability to refuse treatment or to challenge a treatment plan, as long as there's some other treatment that's available. They don't seem to be recommending that there's an ability to simply refuse to treatment at all. So the first change that we get through the new bill is a change to the appropriate medical treatment test. And we looked at that, those of you who were here at the last seminar, we looked at that then. And appropriate medical treatment is no longer sort of, treatment that we hope might be useful, but we don't really know whether it is or not. Instead, it's medical treatment which, taking into account the nature and degree of the disorder, has a reasonable prospect of alleviating or preventing the worsening of one of its symptoms and is appropriate in the person's case. So it's treatment that actually may do some good. And that's one of the, the point about the sort of importance of the therapeutic benefit that runs through the recommendations in the review. So we're getting the new change to that. There's also going to be a new duty under a new section 56A. That's going to require the approved clinician to consider matters that are sort of set out in a checklist when they're deciding whether to give treatment under Part 4 of the Act. So the clinician has to consider a checklist of factors, and these are going to include past and present wishes and feelings, including those that are set out in an advanced choice document, reasonable steps to ensure that the patient has participated, consulting those close to a patient, and also if they lack capacity, they must consider what wishes and feelings the patient might have had. And so those of you who are familiar with the Code of Practice will see that this is essentially a kind of enhanced version of what's in the Code of Practice now on the face of the statute. And this is going to be audited by the second opinion appointed doctor, because when they come along to look at a treatment request, they have to certify that the approved clinician has complied with this new clinical checklist. So the next change that I want to look at is the changes to Section 58 of the Act. And at the moment, Section 58 allows treatment by way of medication of a capacitous patient without consent. New Section 57A says that a patient who has capacity, who refuses treatment, or a patient who lacks capacity but has a valid and applicable advance decision, or has a deputy or attorney who's refusing the treatment, in those circumstances, that patient cannot be given any medical treatment unless two things apply. The first is that there's a compelling reason to provide the treatment. And the second is that there is a SOAD, a second opinion appointed doctor, who is certified that the treatment should be given, and that has to happen before the treatment starts. So the role of the SOAD, the second opinion appointed doctor, is that they have to test whether the treatment that's proposed is appropriate. They have to consult with two people. That's what happens at the moment. The new test that the SOAD has to apply will be that they have to apply the new definition of appropriate medical treatment. So is there a reasonable prospect that the treatment's going to work? They've got to certify that the clinician has complied with the checklist that we looked at a moment ago. They've got to certify whether or not the patient has consented, and the treatment cannot start till the SOAD certificate has been received. And again, going back to what the review was saying, earlier involvement by the SOAD, that is certainly the plan. And then the next change is going to be to what's called the 3-month rule. So at present, the safeguards in Section 58, and that's the SOAD having to certify that the treatment should be given, those only bite after once the patient has been being treated for 3 months. The new provisions is that they will bite after 2 months. So what does that mean in practice? It means that there'll be a 2-month period in which a patient could be treated without their consent. They'd still require the clinical checklist to have been considered, but they could be treated without consent. And I think it is reasonable to sort of think about how many admissions actually last more than 2 months. An awful lot of, quite a lot of people are sort of in and out within that period, so may not even benefit from those new safeguards. The next change I want to look at is some of the changes to the use of ECT, electroconvulsive therapy. That's currently governed by Section 58A. At present, unless it's urgent, no electroconvulsive therapy for somebody who lacks capacity if they've made a valid advanced decision, or they have an objecting deputy or holder of the valid LPA. So that's the plan, is that there'll be no non-urgent ECT. At present, that can be given with the SOAD agreement. There are some changes to the ability to give electroconvulsive therapy in an urgent situation. Currently, if it's considered to be urgent, the AC, the approved clinician, can override the capacitor's refusal of electroconvulsive therapy. or the refusal, or a valid advance decision, or the refusal of an attorney or a deputy. So those safeguards have been tightened up slightly. So the new proposal is that a SOAD must issue a certificate. Before doing so, the SOAD must consult with a nurse and with the patient's nominated person. So that's a change in what the SOAD is doing. They're not just talking to other professionals, they have to talk to the nominated person. Given the potential need for speed, the SOAD can carry out that assessment via video link. Now it's so that does perhaps provide another layer of safeguards. Interestingly, there's a provision in the bill at the moment that the Secretary of State should be able to amend these provisions so that rather than the SOAD going through these processes, the approved clinician actually gets the power back, and they are the ones who makes the decision. Now, there's been an objection to that power, as it's a sort of, it's a kind of Henry VIII power. It passes the law and then allows part of the government to amend that law. It will be interesting to see what actually happens with that. There's some further changes to the urgent treatment provisions. At present, the approved clinician can administer urgent treatment to a capacitous refusing patient on the basis that it's necessary to alleviate serious suffering, as well as other provisions being such as where it's necessary to preserve life or to prevent an irreversible deterioration. But serious suffering is going to go. And what the explanatory notes say is that this change allows patients who've got capacity or competence at the time to decide on the degree of suffering that they are willing to accept. And that the point about that is it's said to strengthen the patient's right to self-determination and to embed the principle of choice and autonomy. So that's a patient who has capacity at the time, even though it's felt to be urgent and it's felt that treatment is necessary to prevent serious suffering. That patient can say, no, I will take the serious suffering, just I do not want this treatment. It doesn't carry across to patients who lack capacity, even if they have made an advanced decision. So if you lack capacity at the time, a decision is going to be made in your best interests. So it's a very limited, fairly narrow exception there. So the next change I wanted to look at in connection with treatment is the new right to a statutory care and treatment plan. Which also applies to those who are on CTOs or on guardianship. And this is going to be a plan that shows how the patient's needs are going to be met in terms of their care or treatment, their leave, or any other issues relating to their life after discharge. So it's got to be done. It's a statutory requirement now. At the moment, of course, it's a requirement in the Code of Practice, but it's being bumped up to have statutory power. And again, a similar example of that happening, of course, is the Care Act, where there's a statutory requirement to provide a care plan. And the statutory treatment plan has a couple of features, so that the patient's case, that the approved clinician has to review the statutory care plan if the patient's case is going to be considered by the Mental Health Tribunal, or if there's a reasonable request by the patient or the nominated person, or following a care and treatment review. So again, a little bit more direction towards sort of, giving the patient or their nominated person some input into their treatment arrangements. So taking all those features into, sort of drawing those all together, I'm sort of asking the question, does this shift the dial? Because this is what Sir Simon Wesley said he wanted his proposals to do, to sort of shift the dial so that the power shifts away from the treating clinicians to the patient. And it left me with the following questions, which we may want to sort of think about together. So my first question is, does this all mean that more patients are going to be assessed as lacking capacity at the time of a refusal of treatment? The next question was about the range of treatments that where the safeguards under Section 58A apply. So at present, these are basically ECT and the medications that you need if you're having ECT. That at the moment is the only treatment that has these, the special provisions in Section 58A. And there's certainly been some discussion about whether other forms of treatment, such as nasogastric feeding or PEG feeding, both of which can all be delivered under Section 63. There's been discussions about whether there should be an amendment to bring some of those treatments into the Section 58A provisions. So that's one question. Is this a missed opportunity to bring some other fairly invasive forms of treatment away from Section 63 into the safeguards in Section 58A? The next question was really, given the number of people who have fairly short admissions, how many of them are going to benefit from being able to refuse treatment without the compelling reason or the SOAD? And will patients know about these changes to enable them in order to consider whether they want to execute lasting powers of attorney or advanced choice decisions? So those were the sort of, that's a sort of overview of how things are going to change. I'm going to hand back to Laura now to see if she's got any thoughts about that, and whether what she thinks about those changes and what difference they might make. And then we can perhaps either have some questions or sort of open things up for a bit more of a discussion. Actually, Anselm, before I do that, in fact, shall we check whether there's any questions first, and then before we hand back to Laura?
Yeah, there are some questions.
Okay, let's.
Maybe I could actually just ask to, I mean, I had a look at the bill this afternoon, and what you've told us is that the decision or wish of a patient with capacity or a donee or deputy can be overridden if a second opinion doctor has authorized the treatment and if there's a compelling reason. But reading the bill, it doesn't seem that the second opinion doctor is authorized to take a different view on whether there's a compelling reason. And secondly, actually, it doesn't say who is to decide that. Presumably, it's the clinician, but in fact, it simply says there has to be a compelling reason without setting out who it is who decides that.
Yeah.
So I don't know if you had a view on that.
Well, I that interpretation is absolutely right. It's not clear what a compelling reason is, and the SOAD's decision making is limited to whether the treatment is appropriate and to considering whether the clinical checklist has been considered. So, I mean, I guess the government's answer will be, well, we'll put guidance in the code about what a compelling reason is. But on the face of it, that is a pure decision for the approved clinician.
Yeah. And it seems to me that, I mean, they've moved away from the traditional model where the question was, does the patient understand the nature, purpose, and likely effects of the treatment, which is quite a defined question. And I think actually most patients in practice do understand that. and change that to whether they have capacity or not. Now, I mean, judges have interpreted incapacity so widely that I often wonder if I have capacity. I mean, if it's going to be that sort of approach, there's going to be huge numbers of people said to lack capacity. Do you have a view on that?
Yeah, well, I think I do think that's going to happen anyway. I can kind of see a logic to saying, well, that formulation about understanding the nature and purpose is a pre-MCA formulation. It essentially means having capacity, and therefore, why don't we just say so? But I take your point that actually it's quite a narrow definition. And so yeah, I think that we are going to see more people assessed as lacking capacity.
Because I think ultimately, if a clinician wants to give a particular type of treatment, they are going to find a way of doing it. And if that means that they need to assess their patient as lacking capacity in a specific area, they will do that, unfortunately.
Well, they wouldn't. It would be less easy for them to do it if their decision that there's a comparative subject to the second opinion doctor's review, but seems that I mean, that's no real protection if the SOAD can't review that as well. But anyway, so there's some questions here, Sophie.
Yes.
So Lyndall says there's already delays with the SOADs.
Absolutely.
And
Absolutely.
I think these SOAD opinions can be by video, can't they?
They certainly can if it's urgent.
Yeah.
And I think the idea is that you've got the 2-month period in which to be formulating your treatment plan and thinking, well, I know I'm going to need to get a SOAD lined up. But yeah, that I don't know how that's going to be accommodated.
No.
There's a real problem.
There's a real problem with resources, I think, with the number of SOADs available. So interestingly, I did some treatment for a group of SOADs in Wales at the end of last year, and I found there's only about a dozen of them for the whole of Wales. So you can imagine that resources are going to be an issue if there's going to be more frequent SOAD reviews. Absolutely. So that needs to be factored in.
Yeah. So there's another question. Will the treatment be delayed while they're waiting for a SOAD review? I think you dealt with that, I think.
Yes. But I think it will. I think potentially, yes, is the answer.
And could you please clarify what the urgent situations are?
So the urgent situations are set out in section 62 of the Act, which says that the safeguards in sections 57, section 58 don't apply to any treatment that's immediately necessary to save the patient's life, or prevent a serious deterioration, or prevent serious suffering, or is immediately necessary to stop the patient from behaving violently. So that's section 62 at the moment.
Yeah.
And it's the serious suffering that's going to go. Everything else will still be taken into account. Good.
Thank you for that. And then the next question, is a tribunal going to be able to say that this patient can stop his depot and be prescribed oral medication instead? And how will that work in practice?
And the answer to that is no. That was one of the recommendations. It was one of the recommendations from the tribunal working group, Anselm, wasn't it? I think that you chaired. It then didn't make, I think it didn't make the final, it was in the review. It then wasn't, but it's not been taken forward in the bill at present. And, arguably that is a real weakness. Now, there were lots of concerns about, how a new treatment challenge power would be quite difficult to manage. And I think there was a suggestion it would just be a judge sitting alone, but able to take advice from a medical member. But that has again, a recommendation that hasn't made it through into the bill at the moment.
So I don't think our group made that recommendation, but I think Simon Westerly and had promised that it would be in his report. Yeah.
Right. It certainly was in his report. My apologies.
Yeah.
Thank you.
Yes. Okay, good.
And Sam, can I have a go at answering some of the questions that Sophie asked on this final slide before we turn over to Laura? Should more treatments be brought into section 58A? I think this is one that I feel quite strongly about. It seems to me that the provisions that we have about ECT are maybe a little bit out of date, and I wonder how frequently ECT is actually used these days. And actually, there are other forms of treatment that are equally restrictive that obviously don't fall under those provisions at the moment. And I'm thinking not just of NG tube feeding, but also NG medication and things like clozapine delivered by NG tube. There's now clozapine available in injections you have to have every day, those sorts of practices. So I wonder whether there's a bit of a missed opportunity there to extend really the safeguards that we have under section 58A to some other forms of treatment that are now available that weren't in 1983. And then, I mean, how many people will be affected by the changes to section 58? I think I agree with you, Sophie, that it's probably going to be a limited number because 2 months is still quite a long period actually in terms of waiting for a SOAD review, and a lot of people will have completed their treatment by that stage, certainly in their first few admissions, but so it may not be actually that large group of people. And how will patients know about the safeguards so that they can consider LPAs or advanced choice documents? Well, I suppose that's where the duty comes into the ICBs, local authorities and NHS England to make sure that people are aware of advanced choice documents, but we'll need to see in practice how many people actually take up the offer of that support and actually take out these legal instruments, if you like, considering that you'll need to get someone to obviously properly witness your signature, etc. Those are just my thoughts on those.
Yeah, that's very interesting, very helpful. So it may be, I think, just check, there might be, no, so that's the question so far. So Laura, could we return to you, please, and you give us your insights and thoughts on the new consent treatment provisions?
Yeah, I guess it might be helpful for me to speak first about what my experiences are of receiving treatment without consent as the Act is currently. So during my first admission, I was, I said earlier that I was NG fed. This was for a period of about 4 months, and at times required restraint towards the start, particularly towards the start of that period of time, but then also at the end of that period of time when I was trying to transition to oral nutrition, but was being denied that option. I was already having probably 60-70% orally, and it was that final bit that I wanted to take orally, but was not being allowed and was therefore being restrained to have that administered, which, having gone from being accepting to a degree of receiving nutrition to having that power taken away was really quite traumatic. And I think that's why, as I said earlier, the advanced decisions side of things potentially could have alleviated some of my fears of that happening again in a second admission. But during that first admission as well, initially, I was being given medication without consent. On that admission, I was taking it orally, and when I reached the point in my admission of the 3 months and there potentially needing to be a SOAD, I was consenting to take those medications, so I didn't experience a SOAD at that time. on my second admission, things were a little bit different in terms of my accepting of medication. I was tried on different medication to the medication I'd had previously, and I didn't find a benefit from those. If anything, I felt like my mental state deteriorated. And I was also needing to have those medications through the NG tube. So that meant that when it came to the time of having to decide whether I was willing to accept the medications, I wasn't willing to accept the medications. So there was a SOAD review. But to me, that felt like a tick box. There was no change, and I didn't feel like me saying these aren't helping changed anything. If anything, more medications were added, rather than changing those. Whether the proposed changes to SOAD would change the impact that SOAD can have, I don't know. The place within the changes that may have had an impact is the implementation of the checklist. And if on that second admission I'd been able to make an advanced decision that if I need hospital admission again, I would like to have the same medications I'd had previously, then I may have not had to go through that, because those medications may have been tried as a first line treatment.
Yeah.
And I think, although at the time I didn't involve my parents massively in my care, knowing that they could advocate for me with decisions made both by the advanced approved clinician and the SOAD would have at least made me feel like I had more of a voice than I did. I know that there were some treatments that I received under the Mental Health Act that I needed. They saved my life. But I also know that there were others that have left me with fears about what might happen should I reach that point again, and which I do on occasion relive. I think, yes, for me, the biggest potential change will be in the use of the checklist. If that is followed, the impact that will have on the SOAD, I'm not so sure, particularly given the limited numbers that Liz and Sophie have already mentioned. In terms of thinking about whether NG feeding should be moved under the same section as ECT, I know that as someone who is quite intelligent and who managed to talk their way out of sectioning, that can seem like they have capacity, but inside there is a huge dilemma, and there's a huge kind of want for someone to take that decision away from me. I think if there were more safeguards around NG feeding, more reviews, more using of the checklist as to whether there are other less restrictive options that would be that could be tried before potentially resorting back to NG feeding if that was needed, would have made a difference. Because like I said, on my first admission, I was NG fed for 4 to 5 months, but there was no review with another independent doctor, and that feels quite frightening, really, that within a team of professionals. There's no one that can come in from the outside and review what's being done. And I guess that would be my kind of thoughts on it coming under the other section. I would be a little worried about potentially being able to appear capacitors as to not wanting NG feeding, when actually a well me would want NG feeding, particularly if I hadn't made that advanced decision that that's what I would need at that particular point. But it would be helpful if there were more safeguards around it than there are at the moment. Whether that will happen, we can't know yet. But does anyone have any questions?
I mean, do you feel, Laura, that one of the weaknesses of the bill is that there aren't any provisions about restraint? You referred to restraint, and I mean, if you go back to the Lunacy Act 1890, there were specific provisions about restraint and seclusion, and they had to be reviewed by the commissioners and so forth. Do you feel that the use of restraint needs to be more independently reviewed or regulated?
I think so, particularly if it's going to be prolonged. So if there's a one-off potentially where it is needed to help someone out of a real crisis point, but there is then provision to work with someone so that that doesn't need to happen. But I think if it's going to be for a really prolonged period of time and repeated, then I would feel safer going into hospital knowing that there would be reviews, rather than it just being able to continue. I remember at the kind of height of the stress, when I was asking to have the nutrition orally but was still being restrained, there was nothing I could do. My parents were unable to voice. There was no role that a tribunal could play. There was no way for me to get that decision reviewed. And it was the restraint aspect of it that made it the most traumatizing.
Yeah. Thank you for that.
I mean, I suppose and just one other thing that's worth flagging at this point is, I suppose, that if you'd had a treatment plan and you'd had, and you had your nominated person, then there would have been there's a point where your nominated person can require that treatment plan to be reviewed. Now, there's nothing more than reasonably requiring it to be reviewed, and there's not much you can do if the approved clinician says, no, I'm not going to review it. I mean, arguably it might be judicially reviewable, but well, good luck with that. But again, as people are sort of trained to say, okay, if someone comes along with a request for me to review their treatment plan, I really have got I can't just dismiss it. I have actually got to show that I'm taking this on board. That sounds like something that might as well be helpful. I mean, I'm actually really encouraged by hearing what you're saying, not so much about the consent provisions, but about the role of the checklist and the role of the advanced documents. I mean, if those are really treated seriously, it sounds as if they could make quite a positive difference.
Absolutely, and it's good to hear. Maybe you're a little bit more optimistic about advanced choice documents than we were. So that's good to hear, because you're one of the people who has a role in looking into that at the moment in your professional capacity. So I think that's good to hear. But I think what struck me from what you said, Laura, about your experience is it's about kind of the hard edges, isn't it? So there was a point in your treatment where you felt yourself that you were getting to the point you were going to be able to accept a bit more nutrition orally, and you weren't listened to at that point. I think that is a concern. And I think it's also, for me, partly about how well the clinical team know their patient as well. And obviously you had a second admission, and it sounds like some of the learning from the previous admission about your medication wasn't sort of taken forward in your second admission. They changed everything. And if there clearly needs to be a better paper trail, doesn't there, I think, really, of what's worked in the past and what hasn't. And actually, as a patient, you're the person who knows that best. And I suppose that's the idea behind the advanced choice documents, that you're able to record that in terms of what you want to have in the future, because you know what's worked for you previously. So I suppose that's the hope from that, isn't it, really, that there might be better continuity as well, particularly for people who get admitted in different places. And we know that particularly eating disorder beds, and I think there was another discussion in the House of Lords, that there's really very limited inpatient provision for eating disorders in particular. So you can end up being sent all over the country for treatment, which is awful and really quite traumatizing, but also breaks that continuity of care, doesn't it? Because you're starting with a new team who don't know you, who don't know what's happened in your previous treatment. So it's sort of bring all those threads together so people understand what matters to the patient as well, I think, what's worked for them previously.
Yeah, and I think for me, because as much as we are trying to move away from needing to send people further away, there will be a kind of a time lag before that happens. And I think for me, there feels like there's a little bit more security in having advanced choice documents as part of the Mental Health Act, so that they can move with you if you move between trusts. I guess not just in the context of being admitted out of area, but also if you geographically relocate somewhere else, whereas trusts can work very differently, and something that they might have as policy or practice within one NHS trust. So currently following people's choices and preferences that they've written in wellbeing plans may not be followed by another trust. So for me, having it as part of the Mental Health Act will hopefully ease some of that transition as people move around. Yeah.
Good.
And that's really important too, because I think that's always a pinch point as well when people transfer between areas or between teams, isn't it? That things get lost in translation. So I think that would also be a positive factor with those.
There's a couple of comments here. While I understand and agree with the need to avoid for-profit hospitals, I wonder what happens if the NHS cannot provide appropriate provision or sufficient appropriate provision. For me, it would be really helpful to focus attention on avoiding admissions in the first place and ensuring robust support is in place on discharge to avoid repeat admissions. There seems to be a big discrepancy in terms of access to crash pads based on postcodes. And then I agree about the need to include careful review of restraint. This causes so much PTSD in our loved ones. 2 comments there. Could I ask both of you, I don't know the answer, but when I last checked, second opinion doctors agreed with the consultant in charge of the patient's treatment in 96% of cases. Is that still the case, or is there cause for optimism that there is sometimes a divergence?
The short answer is I don't know.
No, I should have asked my group of SOADs in Wales, shouldn't I, really? But I didn't ask them at the time. It would have been interesting to know. I will ask.
And I mean, the second thing, I mean, I'm beating an old drum here, but the Care Quality Commission surely needs to go, and it's failed miserably. And we need to go back and have a specialist Mental Health Act Commission that that employs the SOADs and is multidisciplinary rather than under the thumb of the Department of Health and Social Care. And it needs to be charged with monitoring the Mental Health Act, monitoring the Mental Capacity Act, monitoring the European Convention on Human Rights in hospitals and care homes, and investigating patients' complaints. I mean, we've really let patients down badly since 2007 when the Mental Health Act Commission was abolished. So I mean, I would urge people listening in today, if you have any influence at all, try and get your MP to introduce that. If you want to contact me, I mean, I had drafted a section for that in the past.
Thank you very much,
Personal
Anselm.
plea.
Yeah, I mean, that was really debated relatively recently in the Lords. There was an amendment that I think I was just this week, and the answer was, well, it's just going to duplicate the CQC. And as to having a commission that also incorporates the Mental Capacity Act, well, that was the overarching recommendation back in 2014, wasn't it, from the House of Lords scrutiny of the Mental Capacity Act, was there needs to be an overarching body that, a commission that oversees all of this, and that went by the by. So I'm not optimistic, but I do share your thoughts.
I'm not optimistic because what the government doesn't want is proper scrutiny, actually, and therefore it appoints bodies that are under close ministerial control. What we need is a body that is answerable to Parliament, not to the department, and has proper independence. But anyway, off my hobby horse. Are there any? I think we've got 6 minutes left, so let's see. I'd be grateful for the panel's view on self-binding directives. For example, do they see them as any more robust than ACDs?
I mean, I suppose in relation to that, I guess I would, and so I would say it's going to depend what power they're given, aren't they? I mean, so a self-binding directive it's like the Ulysses clause, isn't it? It's, you say, I know that if I get on well, I'm going to say no to such and such a treatment, but actually I'm happy to have it, and you can give it to me. I mean, I can see that having a place.
Okay.
But it would need legislative power, wouldn't it, to make it clear that it was binding. I wonder how many people would really do it if they knew that it was absolutely going to bind them rather than be part of what's going to be generally taken into account. But I know a lot of people feel very strongly that they would be a really positive addition.
Yeah. So the next question, I have a significant number of clients in private hospital beds. Has there been any discussion on reopening NHS wards instead? That would be, God, that sounds just too sensible, but what do you have to say to that?
Well, there was some debate in the Lords about it, and I think everyone was quite shocked at I mean, I should have taken down the figure really, but at the millions of pounds that's spent every year on private units, but there didn't seem to be a clear solution to that, or support for abolishing private mental health care completely. There'd obviously need to be a shift, because there is a huge amount of provision at the moment that's undertaken in private wards, probably a lot more so than physical health, I would have thought. So there needs to be a gradual shift, I think, and probably mental health practitioners would have all found that it's quite often the specialist services are actually run also by private groups. So there would need to be significant work, I think, done, additional resources put back into the NHS for those wards to be reopened as NHS wards, absolutely.
And then the last comment, which warmed my heart here regarding specialist commissions and not the CQC, who are failing in their own areas. There you go. Sophie, I don't know if you'd like to say something. We've got 3 minutes. If you'd like to say something about the next event, which is, I think, on the 4th of March.
Yes, I certainly would. Thank you very much for reminding me. On the 4th of March, we are very pleased to be presenting a hybrid event. So it'll be in person and also online. Oliver Lewis is going to be co-presenting the event with Rightful Lives. Julie Newcomb of Rightful Lives and Oliver will be chairing that event. And it's about improving the protection for those with learning disability and autism. So that's on the 4th of March, same time, 6 to 7:30. All the details are on our website, and it sounds like a fantastic event with a lot of really great speakers lined up. And so I hope to see some of you there. And perhaps I could also just sort of thank everyone for attending this evening. Thank you so much, Liz, for your contribution, and Laura, absolutely brilliant to have you with us this evening. I think you've just given us so many insights that are really, really helpful and actually quite encouraging, which is very nice to see. And thank you, Anselm, for chairing.
Good. Yes, thank you both, and thank you also, Laura, for coming along today.
Thank you for having me.
One last question, which I'm just going to leave with you because it would take hours to answer.
Okay.
If there's another case like Valdo Calacane, do you think the reforms could be halted? So I shall leave that with everybody, and well, maybe
I hope
pick
not.
up on the 4th of March. Yeah. Okay.
Thank you. Thank you very much, everyone.
Thanks. Bye.
Bye.